I am Christina Peck, Principal Counsel of the Asian Development Bank, and we're here to discuss a very important reform. If someone can just mute the background. So it's a reform that's very relevant for less development goals, and we are extremely privileged to convene key stakeholders from the government and the judiciary and eminent arbitration experts representing many aspects of international commercial arbitration. And all of you, in particular, our participants from Timor-Leste, who we had the pleasure to meet during our Dili visit in June 2019, as well as participants who have registered from all around Asia and the Pacific region. In the interest of time, I'll just commence with our opening ceremony. It's my absolute honor to introduce the opening speaker, His Excellency Joachim Amaral, the Coordinating Minister of Economic Affairs since June 2020. He assists the Prime Minister in managing a big portfolio, especially in economic governance areas. He is also the Chief Negotiator for the WTO accession process. Your Excellency, I hand you the floor. Perhaps we can move, while we're waiting for His Excellency, perhaps we can move to, I can introduce you to our country Director Sunil Mitra to make a few opening remarks while we wait for His Excellency Joachim Amaral. Sunil?
Thank you. Can you all hear me? I won't ask everybody, but if some people can respond, that should
loud
be
and clear.
Excellent, excellent. Like Christina said, while we wait for His Excellency to come online, let me just start by saying good afternoon, Your Excellencies, Honorable Justice Soros, ladies and gentlemen. On behalf of the ADB, I'm honored to be here with all of you via the Zoom and welcome you to this special webinar on international commercial arbitration. My name is Sunil Mitra. I'm the Country Director for the Asian Development Bank in Dili. This is a very timely and important topic relevant to Timor-Leste's development, priorities to increase trade and foreign investments. Since 2002, ADB has been Timor-Leste's development partner, and we have been providing project loans and grants and technical assistance to help build the country's infrastructure, as well as strengthen its institutions and human capital. Nevertheless, to enable Timor-Leste to further develop and diversify its economy through cross-border trade and foreign direct investment, to create more jobs and improve the Timorese standard of living, there is a great need to improve the country's investment climate. In this regard, one key reform identified by key trading partners and the foreign investors is a lack of effective dispute resolution mechanism through international arbitration to resolve commercial dispute with foreign parties. Indeed, enacting international commercial arbitration reform will also support Timor-Leste's efforts to join the ASEAN WTO, as all member states have put in place international commercial arbitration legal frameworks already. I understand that since 2017, ADB, along with a team of eminent international arbitration experts who are here with us today, have been assisting the government of Timor-Leste under regional technical assistance on the promotion of international arbitration reform for better investment climate. We are continuing to support this, led by my colleague, Ms. Christina Peck. This technical assistance efforts include accession to the New York Convention, the voluntary arbitration bill. Now, even during COVID times, countries have continued their international arbitration efforts. ADB and UNCITRAL worked together to help Palau and Tonga accede to the New York Convention in April and June. And Uzbekistan adopted a new law on international commercial arbitration in September. In fact, International arbitration reform has been part of several countries' COVID-19 recovery efforts. I now thank you all for taking your valuable time to participate in this important webinar. I hope you get something out of it and enjoy it. Please stay safe and well. Thank you, Christina.
Thank you, Sunil, for those opening remarks and setting the scene. We will move to our experts in international commercial arbitration. So now we will start our journey into international commercial arbitration. And I can't think of anyone better than Gary Bourne to kick off our tour. He's the world's leading authority on arbitration and has been working with the ADB in assisting the government of Timor with this important reform. So Gary, if you're on, I'll hand you the screen.
Thank you so much, Christina. And also thanks to the Asian Development Bank. Christina and the ADB have been real thought leaders, tirelessly working not just in the Pacific Islands, but elsewhere in Asia on projects of legal reform over the last decade, including this particular project concerning international commercial arbitration. I'd also like to thank the government and people of Timor-Leste for giving us this opportunity to discuss a subject that is close to my own heart, hopefully close to the hearts of all of you in Timor-Leste and the other attendees at this virtual webinar. International commercial arbitration is an essential foundation for both cross-border trade and international investment, cross-border investment. Cross-border transactions, whether they're sales of goods, joint venture, intellectual property, insurance, construction projects, whatever the commercial activity may be, present unique risks, particular difficulties because of their international character. As a consequence, for centuries, but in particular over the last 3 decades, businesses around the world, countries around the world, have turned to international commercial arbitration, the arbitration process, to resolve disputes arising out of cross-border trade and investment. The arbitration process is relatively simple. The arbitration process gives the parties, the 2 contracting commercial businesses to a transaction, the freedom to select a decision maker, an arbitrator, who will resolve their dispute applying neutral procedures. The decision, the award of the arbitrator, will finally resolve the parties' dispute and prevent their having to go to a national court in either of their 2 home countries or anywhere else. The arbitrator's award resolving the parties' dispute will be final and binding and will put an end to their dispute, clarify their relations, and allow them to go back to the business of business instead of worrying about legal risks, instead of litigating in national courts. The arbitral process has been favored by businesses around the world for the last decades. If you look at the caseloads at leading arbitral institutions, they've increased exponentially because businesses have chosen to include arbitration agreements in their contracts. At the Singapore International Arbitration Center, where I have the great honor, the great privilege to serve as president of the Court of Arbitration, our caseload went from literally a half dozen cases in the early 1990s to this year, more than 1,000 cases. And that's not a phenomenon that is unique to the SIAC. It's one that one sees at arbitral institutions all around the region, all around the world. Businesses look to arbitration as the preferred means, the natural means to resolve their commercial disputes. Countries have taken the same view. Nations around the world have taken the view that it is important to facilitate cross-border trade and investment by providing a reliable, a trusted means of dispute resolution. They've therefore acceded to the New York Convention, the short title for the United Nations Convention for the Recognition and Enforcement of Foreign Arbitral Awards. The convention requires contracting states to recognize and enforce international arbitration agreements, and also to do the same for international arbitral awards, subject only to carefully defined and narrow exceptions. More than 165 contracting states around the world, virtually every state of any economic significance, has ratified the New York Convention. At the same time, those countries have also adopted legislation, in many cases, the UNCITRAL Model Law on International Commercial Arbitration, that implements the New York Convention, and again, provides a means for international arbitration agreements to be enforced and international arbitral awards, likewise, to be recognized and enforced. Why is it that businesses, why is it that countries, virtually all countries in the world, have looked to international arbitration to resolve their cross-border commercial disputes? I like to think so because of what I call the 5 E's. International arbitration is, as compared to the alternatives, more expeditious, more efficient, more even-handed, more expert, and more enforceable. And in the few minutes remaining for my talk with you today, let me outline just very briefly what each one of those E's, the 5 E's of international arbitration, stands for. International arbitration is more expeditious than the alternatives in national court litigation because the parties can design the procedures and the arbitral tribunal can design procedures suited, hand-tailored to specific parties and specific disputes, instead of having one-size-fits-all procedures that are imposed on them externally. Many arbitral institutions have adopted fast-track procedures as a means of expediting the arbitral process, the dispute resolution process. Because arbitration is more expeditious and doesn't present the obstacle of multiple layers of appeal in different national courts, it's also more efficient. It costs less. If you only have to do something once, not 2 or 3 times in different courts in different countries, naturally it will cost less. Time is money, as they say. Arbitration is also more expert. It's more expert because, as I mentioned a few moments ago, in the arbitral process, parties have the option to choose the arbitrators themselves. The parties know best of anyone in the world what their dispute concerns, what the real facts, what the real issues are. And they have the greatest incentive to pick the best decision makers to resolve that dispute. Unsurprisingly, the parties pick arbitrators who are expert as compared to having someone randomly chosen, arbitrarily selected without regard to the subject matter. If you have an insurance dispute, you have a construction dispute, you choose an insurance expert or a construction expert. Finally, arbitration is more even-handed. Instead of having a dispute resolved in one party's home courts, the dispute is resolved in a neutral arbitral jurisdiction with a neutral arbitral institution selecting the arbitrators. Inevitably, that provides a more even-handed, a more neutral and objective means of dispute resolution than if a national court were to resolve it. And finally, arbitration is more enforceable because of the New York Convention, which I mentioned a few moments ago, and because of national legislation, making arbitration agreements and arbitral awards enforceable around the world. National court judgments do not benefit from any similar international treaty, and as a consequence, lack the enforceability premium that arbitral awards and arbitration agreements enjoy. Because of those 5 E's, making international arbitration a superior means of dispute resolution, the natural means of international commercial dispute resolution, both parties and countries choose to resolve their disputes in that manner. And Timor-Leste, by adopting the New York Convention and legislation to implement the convention, will join with other countries around the world in providing the essential infrastructure for cross-border trade and investment to occur even-handedly, efficiently, and expertly. I hope that introduction to the reasons for international arbitration has been useful, and certainly welcome any comments and look forward to an opportunity to answer questions if we have that at the end of the program. Thank you very much, Christina.
Thank you, Gary. Thanks for explaining to us the benefits of international commercial arbitration. So our next expert, I'd like to introduce you to Mr. Jae-Sung Lee. Basically, he's from UNCITRAL Vienna office. They've been our longstanding development partner who we have been collaborating with on international arbitration reform in various countries. Gary mentioned the two key instruments, the New York Convention and the UNCITRAL Model Law. And Jay will give us a more in-depth explanation on that. So Jay?
Thank you, Christina, and good morning to you all from Vienna, Austria. As introduced, my name is Jae-Sung Lee, and I function as the Secretary of the UNCITRAL Working Group 2 on Dispute Settlement. 5 minutes is a bit short to dive into depth about the UNCITRAL text in dispute settlement, but I'll try my best. A number of references have already been made to the New York Convention and the UNCITRAL Model Law on International Commercial Arbitration, and you will hear more from the speakers that follow. In fact, UNCITRAL is a well-known name in the area of dispute resolution, but its scope of work is a lot broader. Established by the UN General Assembly in 1966, the United Nations Commission on International Trade Law, often known as UNCITRAL, is actively engaged in the progressive harmonization and modernization of the law of international trade. And we do so by preparing international legal standards in different areas from contracts, transports, e-commerce, insolvency, and to secure transactions. Now back to arbitration. It can be said that the international arbitration framework is solidly grounded on UNCITRAL text, beginning with the 62-year-old New York Convention. By becoming a party to the convention, states, and its courts mostly, agreed to recognize arbitral agreements and refer parties to arbitration when there is such an agreement. And they also agreed to recognize and enforce foreign awards rendered through arbitration with limited grounds for refusal. The New York Convention now has 166 state parties, with Sierra Leone joining this October, and thus can be said to have been universally accepted. The UNCITRAL Model Law on International Commercial Arbitration has influenced arbitration laws around the globe. A number of states in the Asia and the Pacific have been increasingly embracing the model law, and we see this as a welcome development. Not only does the model law provide a legislative framework for state legislators to follow, the model law stamp provides assurance to foreign investors and businesses as they start to engage in transactions with and in Timor-Leste. Legal uncertainty hinders cross-border trade and investment, and this is why whether a state is a model law country or not makes a big difference. In general, a jurisdiction that has enacted the model law is seen to be arbitration friendly, or in other words, more open to the principles underlying arbitration, mainly that the parties should be given the freedom to resolve their disputes as they like. Now, enactment of the model law thus gives a sign to the foreign investors that the government is willing to allow parties to resolve disputes through arbitration with the support and supervision of local courts. I'd also mention that the UNCITRAL arbitration rules provide a comprehensive set of procedural rules upon which the parties may agree on for the conduct of arbitral proceedings, particularly in an ad hoc setting where there is no institutions to support the parties. Now, while some people, particularly those in the media, refer to UNCITRAL arbitration, we at UNCITRAL do not administer cases. Our role is to formulate international legal standards and to support the working groups and the Commission in finalizing and adopting those texts. I would note that the Working Group 2, which I function as the Secretary, is currently preparing the expedited arbitration provisions to accompany the UNCITRAL arbitration rules, which should be geared towards expedited arbitration to save time and cost of the proceedings. They are expected to be adopted next summer in 2021. The Secretariat has also prepared a number of guidance documents, such as the Secretariat Guide on the New York Convention, the notes on organizing arbitral proceedings, which may be of interest to our colleagues in Timor-Leste as you go about reforming your arbitration framework. Now, while legislating or making international norms is the main business of UNCITRAL, promoting such texts and providing technical assistance to states in implementing UNCITRAL text in their reform are two other key pillars of our business. We advise government representatives on how to become a party to the New York Convention, how to deposit their instrument of accession, and what reservations are to be made, if any. We also provide comments on draft legislation to ensure compliance with the model law and advise how different domestic interests can be embedded in the domestic law without departing from the main principles of the model law. We also advise arbitral institutions that are in the process of preparing new rules and that are prepared to administer arbitration under the UNCITRAL arbitration rules. And for these purposes, we have set up a UNCITRAL Regional Center for Asia and the Pacific in Incheon, Korea, and some of our colleagues have joined today, including the head of the regional center, Ms. Atita Kominder. So you are in close vicinity to UNCITRAL than you may have thought, because the base or the headquarters are based in Vienna, Austria. I know that my 5 minutes is up, but let me reiterate that we at UNCITRAL stand ready to support arbitration reforms in Timor-Leste, along with the ADB and other experts on this panel today. We look forward to issuing a press release in 2021 that Timor-Leste is the 167th state to become party to the New York Convention. Many thanks, and back to you, Christina.
Thank you, Jay. Perhaps this is a good time to maybe switch it up. Next is Jonathan Lim. He's counsel with Wilmer Cutler in London, and he's actually helped draft the arbitration bill along with Gary and Mr. Daniel Meltz and our government partners, Dr. Polo Duarte and Dr. Melissa Caldes, and hopefully they're on. Johnny is actually one of the smartest arbitration lawyers I know, and don't let his youthful looks fool you, but he'll just explain quickly in less than 5 minutes about the draft arbitration bill. Thanks. Johnny?
Thanks, Christina. I've got 5 minutes to tell you about a very comprehensive and well-drafted law. We were very privileged to work with Mr. Paulo Duarte, as well as members of the Timor-Leste government, and with UNCITRAL as well, late last year. I'm going to talk about some important aspects of this law. I think first and foremost, it's a very important step forward for Timor-Leste. As we understand it, arbitration is currently referred to under several discrete laws in Timor-Leste. For example, Section 123 of the Constitution expressly acknowledges the existence of arbitral tribunals. However, apart from these references, there is no comprehensive legislation in place that regulates how arbitration takes place in Timor-Leste, or how foreign arbitral awards or international arbitration agreements will be enforced. The draft arbitration law is significant because it sets out a legal framework for supervising arbitration proceedings, providing guidance to courts in Timor-Leste, and also regulates the enforcement of international arbitration agreements and the enforcement of foreign arbitral awards. Importantly, it's consistent with the obligations of contracting states to the New York Convention. So 2 provisions of the draft arbitration law are key in this respect. The first is Article 12, which is based on Article 2 of the New York Convention and mirrors Article 8 of the UNCITRAL Model Law. It provides that a court must refer parties to arbitration where an action is brought in respect of the subject of an arbitration agreement, unless that agreement is null and void, inoperative, or incapable of being performed. The second is Article 65 and 67 of the draft arbitration law. And these deal with the enforcement of foreign arbitral awards and provide for their recognition and enforcement subject to very limited grounds of non-enforcement that are essentially based on Article 5 of the New York Convention. So together, these provisions implement the obligations of contracting states to the New York Convention, obligations that Timor-Leste will have if it accedes to the New York Convention. More importantly, the draft arbitration law is also consistent in many respects with the UNCITRAL Model Law and adopts many of its provisions. To give you a number of examples, Article 7 of the draft arbitration law provides for minimal court intervention, consistent with Article 5 of the Model Law. Article 8 sets out the requirements of an arbitration agreement in writing and reflects modern understandings of what constitutes an arbitration agreement in writing. It's permissive, allowing arbitration agreements containing electronic communications as well as oral or tacit agreements that are recorded in writing. Articles 15 to 21 deal with the constitution of the tribunal, one of the most important parts of the arbitral process, and essentially mirror Articles 10 to 15 of the UNCITRAL Model Law. Articles 29 to 39 deal with interim relief. These are measures parties might seek prior to the constitution of an arbitral tribunal or when the tribunal is constituted that seek to maintain the status quo or preserve evidence or assets. And Article 61, importantly, deals with the setting aside of international arbitration awards. This is, again, limited to the restrictive grounds set out for setting aside in Article 34 of the Model Law, and that essentially tracks Article 5 of the New York Convention. In adopting the Model Law and implementing the New York Convention, the Timor-Leste draft arbitration law already is very up-to-date and comprehensive. But it goes a bit further and reflects further modifications or innovations that track international best practice since 2006, as well as issues of special interest to Timor-Leste. I'll touch on 3 of these before I conclude my short presentation. The first is Article 42 that addresses the confidentiality of proceedings. This provides that arbitrators, parties, and arbitral institutions must keep the subject matter of the dispute as well as documents arising in the course of the dispute confidential, subject to a list of defined exceptions. That reflects modern practice in jurisdictions such as Hong Kong, Australia, and Singapore. Article 16 of the draft arbitration law is fairly modern. It addresses the appointment of arbitrators in a case involving multiple claimants or multiple respondents. Multiple parties are increasingly common in arbitration disputes, and Article 16 provides for what happens when a group of claimants or a group of respondents fail to agree on their arbitrator. In general, it provides for the power of the President of the Court of Appeal to appoint all of the arbitrators where that happens. The purpose of this is to ensure equality amongst participants and to protect the ultimate enforceability of the award. Finally, Article 11 of the draft law deals with issues to do with the law governing the arbitration agreement. Article 11, subarticle 2 addresses this issue in the case of international arbitrations. And in a somewhat modern take on such a provision, it provides that the arbitration agreement shall be valid so long as it is valid under any of the following laws: the law chosen by the parties to govern the arbitration agreement, the law applicable to the substance of the claim, or Timorese law. As you can see from that brief presentation, the draft arbitration law is an up-to-date and comprehensive piece of legislation that is more than fit for purpose. Along with Timor-Leste's accession to the New York Convention, we believe that its enactment will bring Timor-Leste closer to its aim of making the country attractive for foreign investment. Thank you.
Thank you, Johnny. Thanks for providing that brief overview of the arbitration bill. We really look forward to supporting the government of Timor to progress the arbitration bill. Next, we have Mr. Daniel Meltz, who's an arbitration guru. He's like a practitioner, arbitrator, and academic, and now we even consider him as a development professional. He's been working with the ADB to assist various countries in enactment of arbitration reform. and also manages the ADB's capacity building program. So, so Daniel's going to tell you, what the role of the arbitrator is. Daniel?
Thank you very much, Christina, and hello everyone from Sydney. I want to just take this opportunity to thank Christina and Gary and Johnny, who I've had the privilege of working with for the last few years on this project, and in particular to the Timor-Leste government, which has participated wholeheartedly in this project as well. One of the key drivers of what this entire technical assistance project is about is first to drive foreign investment into countries by making them more attractive. You've heard about that already. But the second issue is what is left? What happens if Timor-Leste does accede to the convention and enacts this legislation? Well, there are going to be a number of opportunities and benefits that can potentially flow from enacting this legislation and acceding to the convention, where Timor-Leste is a seat of the arbitration. And I come at this from the angle of someone who not only participates in this ADB reform, but I've also been privileged to act as counsel in Timor-Leste arbitration as well. And so I've seen it from that point of view, and I've seen already the level of knowledge in this area in certain industries, and particularly in oil and gas, in construction as well, which are the natural fora for international arbitration. And Timor has substantial plans into the future as to how these industries and areas are going to develop, and arbitration is really going to be the cornerstone of any dispute resolution where you have a lot of foreign parties coming and investing in the country. Now, in terms of arbitrators and how that works, one of the features, as I mentioned, is what is going to be left after this reform, and that is that there is going to be a significant role for both counsel in Timor-Leste, but also to develop a pool of arbitrators who would be able to be appointed by parties not only in Timor-Leste, but also, one would imagine, around the South Pacific as well, in terms of being able to act either as a neutral for those other countries or as a representative or an appointee of a party, a Timor-Leste party that was involved in an arbitration with, let's say, 2 other arbitrators. Now, in terms of arbitrator selection, that's an interesting process. Parties are often guided by their legal counsel, because the legal counsel will have worked in that area for a while and will be able to give recommendations. But a few points to note are, first, the benefit of arbitration, or one of them, is that you have access to expertise. So if you have a construction dispute, you can appoint someone who has significant experience in construction. You don't have to start again. You may come before a court, and the judge you come before has principally been involved in criminal law for their life and isn't entirely keen on a large construction dispute. So you have that benefit. The second area to think about is that with institutional arbitration, some of the institutions actually keep a panel of arbitrators who they appoint from, a pool. And in order to become part of that pool, you already have to have had some experience and be recognized by your peers as having that type of experience to get on that panel. And the third point to make in this regard is how can Timorese lawyers or experts in their field develop into arbitrators available to participate in this reform into the future? And there certainly are training courses that are offered. The Chartered Institute, for example, Chartered Institute of Arbitrators offers a concrete course, an intensive course that could be 2 weeks duration. And that gives individuals the fundamentals required for being appointed as arbitrator. So these are all opportunities going forward as to how this process can develop into something that is going to be of concrete benefit, hopefully, to Timorese into the future. So I'll conclude with those remarks and thank everyone for attending tonight.
Thanks, Daniel. Certainly the development of international commercial arbitration would open up new opportunities for the practitioners and the legal community. Next, I have the absolute privilege of introducing the Honorable Justice Duarte Tillman Soares from the Court of Appeal, who has taken his valuable time to share his judicial perspective on this reform. Justice Soares?
All distinguished participants to this webinar, thank you for the opportunity to make a few points for me. I haven't been a judge since 2000. I have had the privilege of being intimately involved with not only the establishment of the justice system, but also have accompanied the development of the legal framework, especially the business and investment laws. We still have to decide and appeals relating to civil and fiscal disputes. We learn much about the inability of our formal court system, the commercial laws, and our civil procedure code in providing the appropriate, effective, and efficient means of dispute resolution for commercial litigants, especially international business and investors. Business demand a quick response and turn around their disputes, which unfortunately our case overburdened system cannot provide at this stage. The different language used in judicial process is also varied for foreign litigants. With the benefits of assistance from the UNCITRAL, I have been one of 2 senior judges in Timor-Leste judiciary who have participated in region and the international workshop and conference to promote enhance the work of organization and alternative dispute resolution, including commercial arbitration. We primary concern is and has always been to provide solution for the litigants who come before us. As I said, our national courts are currently heavily inundated with both criminal and civil case loads, and do not yet have enough justice officers to respond adequately. I was the administrative judge in Dili District Court. By far, the large court is in the country with biggest case load. In District Court, I was called even to advocate on very large petroleum tax dispute between the state of Timor-Leste and international petroleum companies. And I then had the privilege to follow closely the large petroleum tax dispute was eventually arbitrated in Singapore. Is clear to me the enacted of the voluntary international commercial arbitration law is essential in providing some of the solution as I referred to. We understand that the model law, which follow the International Model Law, has been approved by the government and is currently in our national parliament. There is also a proposal for the Timor-Leste Parliament to ratify the New York Convention, as well as the request for the Parliament to authorize the government to make the legislative change to the Civil Procedure Code to accommodate the entry of New York Convention and the new model law into our legal system. Regarding to the proposed amendment to the Civil Procedure Code, it would make the system for registering and executing on foreign arbitral awards much simpler. For example, from one of the current situation under the Civil Procedure Code, the imposition of foreign court decision and arbitral tribunal awards is subject to the recognition and confirmation procedure to be carried out by Court of Appeal. as regulated in Article 672 of Civil Procedure Code. Second, legally speaking, any sort of relief established in the decision or award, provided is not contrary to the public international order to the state of Timor-Leste. This is less straightforward and clear path to the registration provision mandated in the New York Convention. We welcome this crucial development in the draft proposed voluntary arbitration law, the ratification of the New York Convention and amendments to the Civil Procedure Code, and await their successful conclusion as soon as possible. The Timor-Leste judiciary has also recently completed and submitted the Minister of Justice a long overdue draft of law on the administrative structure of the law codes, creating a specialized code for civil, criminal, and family jurisdiction, and also better organization of the geographic administration of justice throughout the country. There is still a need to increase the number of the judges. As is evident, is clearly not enough to deal with commercial dispute as well as the other essential administration of justice in areas such as criminal, labor, administrative, and family laws, etc. The creation of a specialized court with a specific jurisdiction over civil commercial matters will enhance the access to commercial arbitration by litigants in Timor-Leste. The Timor-Leste judiciary welcomes alternative dispute resolution mechanism that would take the burden of courts through arbitration as well as mediation and conciliation. Conciliation is already provided for an integral and binding part of the process in our Civil Procedure Code, but has not been an effective tool to resolve disputes. Work needs to be done in preparing in the judiciary, legal profession, and the private sector to make these alternative dispute resolution mechanism more effective. We are confident, given the number of commercial cases that we have seen coming into the courts, that the enactment of the voluntary arbitration law, the ratification of New York Convention, and other supporting legislative reform to the procedure code, Civil Procedure Code, will result in increased number of commercial arbitration involving Timor-Leste litigants. Indeed, we are confident that within the next 10 years, we will see the emergence of an international commercial arbitration center in this country because of our distinct and unique legal system from other countries in the region. I think that I can share to you, and thank you for opportunity to make this contribution, the very important subject of the development of international commercial arbitration in Timor-Leste. Lastly, I thank the Asia Development Bank and UNCITRAL for its support and look forward to this continued support in future. Thank you for attention.
A huge thank you, Justice Soares, for providing us, some information on the progress and the challenges that the Timor-Leste judicial system faces. We look forward to engaging you on our commercial law capacity building program. Again, thank you. Next, we move on to Mr. Avinav Bhushan. He's the Director, South Asia of International Chamber of Commerce Arbitration, ADR, and International Court of Arbitration. He's very well known in the arbitration world and has been contributing his time and thought leadership to our reform. Avinav?
Thank you, Christina. In the short 5 minutes that I have, I'll perhaps just very quickly focus on the difference between ad hoc and institutional arbitration. Now, as Gary had very helpfully explained, the 5 E's of arbitration, which was expedition, efficient, even-handed, expert, and enforceable, I'll perhaps dare to add one more E to the process of arbitration, which is it's exclusive or private, or as Johnny helpfully explained, that the draft arbitration bill, section 42, talks about confidentiality. Now, the difference, the stark difference between the two, that is ad hoc and institutional arbitration, is that when you have an administering institution, whether it's the ICC or whether it's SIAC or it's LCIA or HKIC, and there are very good arbitral institutions in the region now, the task that an institution performs would be absent when the parties are experiencing an ad hoc manner of arbitration. And these are the tasks that are exclusive to an institution. So when you have an institutional arbitration clause in your agreement, the institution essentially will review your correspondence and submissions on a day-to-day basis, which would be absent otherwise. The institution will supervise and assist the work of the tribunal. The institution will regularly engage in discussions with the tribunal when the tribunal is trying to deliberate and adjudicate on the matter. The institution will also provide neutral advice to the parties to the tribunal on the interpretation of the institutional rules in itself. The institution, equally importantly, will financially monitor the case. It will look into the fees of the tribunal, the time and the expenses that the tribunal has incurred, and monitor that from the beginning until the very end of the procedure. And of course, the institution will assist the parties when the parties will file their initial request for arbitration on issues related to constitution of the tribunal, on issues related to the seat of arbitration, well, that's exclusive more to the ICC, on replacement, on challenges to the arbitrators, on the reconstitution of the tribunal. And perhaps I cannot state the importance of this particular aspect of the institutions enough, which is the award scrutiny. Most institutions now scrutinize arbitral awards. And following that, the application for correction and interpretation of the awards. Now, all the things that I just mentioned would not happen in an ad hoc arbitration. In an ad hoc arbitration, the parties are pretty much following the national legislation without the supervising authority, without the supervising institution. And as we are moving towards the advancement of international arbitration, as more and more countries are beginning to sign the already much subscribed New York Convention, the world is moving to institutional arbitration as opposed to ad hoc arbitration. Now, I work for the ICC International Court of Arbitration. We are perhaps one of the oldest arbitral institutions in the world. We started in 1919, and the ICC International Court of Arbitration was established in 1923. We are headquartered in Paris, but I think we are one of the only arbitral institutions which actually administers arbitration outside of its headquarters. So we started in Paris, but then we opened our first overseas offices in Hong Kong, and we administer arbitrations from there. Then we started administering arbitrations from New York, followed by Sao Paulo, and the latest or the newest team was opened in Singapore in 2018. When it comes to Timor-Leste, Papua New Guinea, this part of the world, the ICC has been administering a host of cases from this region. And in the last 10 years, we've had at least 9 parties from Papua New Guinea. We've had 5 from Samoa. We've had 3 from Fiji. We have 1 from Guam. And last and certainly not the least, we've even had experiences in dealing with energy cases coming out of Timor-Leste. Most of the cases that arise out of this part of the world are now administered in the Singapore offices, where there is a very talented team of lawyers who looks into cases that arise out of this region. So in addition to the 7 teams in Paris, 4 overseas, next year the ICC is likely to open its 12th case management office in Abu Dhabi. Having administered over 25,000 cases all around the world, the ICC's commitment to the region is to continue assisting in thought leadership in building international arbitration, and in this pursuit would continue to help ADB and other organizations to promote the knowledge of international arbitration. Thank you.
Thank you, Abhinav. Our next speaker is Deborah Tompkinson. She's the Secretary General of the Australian Centre for International Commercial Arbitration, another leading international dispute resolution center. It's a real privilege to have Deborah with us today. Deborah?
Thank you so much, Christina. Good evening, everybody. And thank you again, Christina and the Asian Development Bank for organising this really important session and inviting me to be a part of it. In the brief time that I have, I'm going to touch on the role of the Arbitration Institution to add to some of the points that Abhinav just made and provide you with an introduction to the Australian Centre for International Commercial Arbitration, which is Australia's international dispute resolution body. So ACICA was established in 1985 as an independent not-for-profit organisation. It provides a range of services to facilitate the efficient resolution of commercial disputes, including acting as an administering body under its own sets of arbitration rules, as well as under the UNCITRAL arbitration rules. The most recent edition of the ACICA arbitration rules was brought into force in 2016. We've just undertaken a very intensive process to review the rules that have just been through public consultation. We've now nearly reached the conclusion of that process, and we expect that the next edition of our rules will be released in the first half of next year. The focus in that review by our Rules Committee has really been on increasing procedural efficiencies and refining the ease of the user experience to arbitration. The ACICA Rules Committee is made up of people who practice extensively through the Asia Pacific region, and the aim is to bring that broad experience and expertise to apply to the committee's work on the rules. So the current rules incorporate emergency arbitrator provisions, mechanisms for joinder and consolidation, expedited procedures, and a requirement for the tribunal to raise with the parties the possibility of other dispute settlement techniques. As was discussed earlier, Gary mentioned a lot of the institutions have expedited processes. ACICA has a separate set of expedited arbitration rules, and these are designed primarily for lower value and less complex matters. And we also run cases under our mediation rules. Many of ACICA's cases arise from the construction infrastructure and energy and resources industries, these being sectors that Gitanjali, Bajaj and Joe Delaney will be speaking about in a minute later in the session. And ACICA has established a separate Maritime and Transport Arbitration Commission called AMTAC that specialises in the conduct of maritime arbitration and has its own set of rules. And in addition to the role that we take as an administering institution, ACICA acts as an appointment body under ad hoc agreements, under the UNCITRAL arbitration rules, and it's a body that's prescribed by the Australian government as the sole default appointing authority, competent to perform the arbitrator appointment functions under Australia's International Arbitration Act. So just by way of background, the International Arbitration Act in Australia incorporates the UNCITRAL Model Law, and through the designation that's been made, ACICA can act to prevent deadlock or failure of the arbitration agreement by dealing with applications from parties for the appointment of an arbitrator where either Article 11.3 or 11.4 of the model law applies. That being where the parties have not agreed a procedure for the appointment or where the parties' agreed procedure has failed. So arbitral institutions such as ACICA and the ICC, as Abhinav was speaking about before, as well as many others in the region, play a really vital role and provide significant value at all stages in the life cycle of an arbitration. More recently, we've also seen institutions taking on greater leadership roles in shaping the future direction of arbitration by introducing innovations to their rules, to their practices, and committing to initiatives such as the Equal Representation in Arbitration Pledge. And these things ultimately reform and develop arbitration practice. So there's a really strong role for arbitration institutions to take. In this regard, in 2016, to complement the new rules as they were at the time, AKICA established our Practice and Procedures Board to assist with initiatives that are aimed at providing thought leadership and guidance on best practice standards to parties that are involved in arbitration in this region. The membership of that board consists of experienced arbitration practitioners from around Australia and the broader region. That board has developed a series of guidance documents, which are all available in the resources section of our website. They're aimed at assisting parties no matter the level of familiarity that you have with the arbitration process. And many institutions have their own resources that parties might find really useful in terms of developing their understanding of arbitration. For the purpose of my topic today, one of the useful documents that the Practice and Procedures Board recently developed neatly summarises the role that AKICA as an institution plays in adding value to arbitrations. This goes right through the process of arbitration, starting at clause drafting, where institutions provide clear and enforceable model clauses, works through the commencement stage of an arbitration, where the involvement of an institution can be crucial to ensure that the procedural requirements are met for the proper initiation of the arbitration, through the appointment process, applying expertise and experience to various applications, consolidation and joinder, challenges, and expedited processes are just some. Moving through the arbitration process, AKICA takes an active role in case management to ensure that the overriding objective of our rules is observed, that being to provide arbitration that's cost effective, efficient, and fair. We also take proactive steps to ensure that the arbitration is issued in a timely manner. Our expedited rules contain time limits for the award to be issued, and the Rules Committee is currently considering introducing time limits into the next edition of our arbitration rules. Our case management role extends to financial management. So institutions can really help parties in terms of providing greater certainty of cost and alleviating the burden on both the parties and the tribunals in managing deposit taking and payments. In essence, as Abhinav has already noted, using an institution can contribute greatly to the stability and certainty of the process. The supervision that an institution provides enhances the likelihood of a final enforceable outcome, which, drawing us back to today's topic, is critical to promoting cross-border business confidence through arbitration. So I will conclude there. Thank you.
Thanks, Deborah. Thanks for explaining to us all the good services that our arbitration institutions provide, as well as innovations to make it easier for the users. The next, so just to let you all know, we have about 3 speakers left. So the next 2 speakers are practitioners that'll bring, I guess, the whole arbitration mechanism together and explain how it fits into 2 key sectors that are really relevant for Timor-Leste. Our next speaker, Jo Delaney, she's a partner with the law firm of Baker McKenzie, based in Sydney. In addition to her very busy schedule as an arbitration practitioner, she's also been lending her time for this reform and also contributing to our capacity building activities. Jo?
Thank you, Christina. And thank you to the ADB for including me in this initiative. Thank you, Your Excellencies, and all the attendees today for joining us on this very important topic. So I thought I'd give you a bit of a practical viewpoint of how arbitration can assist in East Timor. And one of the areas where it's likely that arbitration will come up will be in infrastructure and construction projects. And these could be projects relating, for example, to power plants, to a road project, it could be a solar or wind farm, or it could be even a commercial building. And the construction of these types of projects will often involve companies from different countries, or perhaps a multinational company operating around the world. These companies have expertise and experience of the specific types of project being constructed. And it may be that the builder or main contractor will also involve subcontractors on specific parts of the work. So for example, it may be that if you're building a power plant, you would involve a subcontractor who would do the fabrication of the steel. And that company could come from another country. So it's highly likely that in these construction and infrastructure projects, the project will involve many different companies from many different countries. It may be 2 or 3, but it could be even more, could be 10 or more countries. Now, if a dispute arises between 2 parties or even more than 2 parties, that dispute could be referred to the courts in Timor-Leste or the courts of one of the countries from where the companies come from. But there are problems sometimes with referring these types of disputes to the courts. Daniel mentioned that sometimes the courts are not necessarily experienced in that particular area. It may be that they already have a very heavy caseload and very many complex disputes to deal with. But the most important issue really is enforcement. And we've already mentioned the New York Convention, and I'll come to the key benefits to talk about how arbitration can assist with these types of complex projects where you've got many different companies involved from different countries. So one of the first benefits to mention, and this goes back to the 5 E's that Gary Bourne mentioned early on. So the first benefit is that many of the companies are familiar with the arbitration process. They've been involved with construction projects before and also construction arbitrations coming out of those projects. It's a flexible process that can be developed and adapted to suit the particular dispute so that there is a cost and time efficient process, focusing on trying to get a relatively quick decision to give the parties some certainty and outcome. So the process is focused on identifying the key legal and factual issues. It is designed to bring those issues out through written submissions, through written advocacy, as well as through oral advocacy. And there usually will be a hearing. It will involve extensive evidence. There'll be witnesses, documentary evidence, and usually expert evidence. And through a timetable agreed with the arbitral tribunal, the tribunal will control the process so that it can lead to a hearing as soon as practicably possible and reasonably possible for the complexity of the dispute. And then the tribunal will be able to issue a decision in the form of an award. And that brings me to the second benefit, which is choosing the tribunal. And Daniel mentioned a little bit about the appointment of the arbitrators. So one of the key benefits of arbitration is that you can choose arbitrators who have the relevant expertise and experience for dealing with a specific type of dispute. So for construction and infrastructure disputes, you may be looking at arbitrators with specific legal experience, like the law governing that type of dispute. It could be Timor-Leste law, it could be law of England, Singapore, Australia, or another law. Construction contracts are complex and there are many standard clauses and also standard form contracts that are often used that arbitrators are familiar with. The arbitrators may have practical experience of this type of project. It may be a renewables project, for example, and they've dealt with disputes coming out of other renewables projects. Or it may be that they have experience in the Pacific region, and that will also assist them with deciding this dispute. But the most important benefit is enforcement. So when you have companies involved in a project coming from different countries, there may be an issue when it comes to enforcing a court judgment in the country where that company comes from and where the assets are located. the two countries involved, so where the court judgment comes from and where the court judgment is to be enforced, may not have reciprocal arrangements, and it may not be possible to enforce that court judgment. So for example, it may not be possible to take a court judgment from Timor-Leste to another country such as China to enforce it. But one of the benefits of having an arbitral award and an arbitration which leads to an award is that you can enforce that award in all of the countries that are party to the New York Convention. And as Gary mentioned, there's more than 165 parties now. So that means that companies involved in these construction projects will have more confidence that if there is a dispute that arises out of the project, they will be able to go through a dispute resolution process that is cost efficient, time efficient, and that will ultimately lead to a remedy that can be enforced, so that at the end of the day, they will be able to get an outcome that is effective. Thanks, Christina. I'll pass it back to you.
Thanks, Jo. So now I'll introduce you to Jintanjali Baha. She's a partner and co-head of the International Arbitration Group of DLA Piper based in Sydney. She's no stranger to Timor-Leste as she's been working with the government for many years. Jintanjali has vast experience in the oil and gas, power and clean energy sector. Jintanjali?
Thank you, Christina, and thank you to the ADB for the opportunity to participate in this evening's seminar. As Christina mentioned, this is probably the longest I've gone without visiting Delhi, so this is all the more special to me, that too on an auspicious day like today and the day after Memorial Day. So hello, everyone. Thank you for giving us your time today, as I know that this is a holiday time for you as well. I'm going to use my 5 minutes to speak on arbitrating oil and gas disputes, something that I'm quite familiar with in the context of Timor-Leste. As everybody in the audience already knows and appreciates, Timor-Leste has a very sophisticated, mature, and advanced petroleum sector. And so Timor-Leste, as a host state, regularly enters into production sharing contracts through the ANPM, the National Petroleum and Minerals Authority of Timor-Leste, with contractors from all over the world for the exploration and exploitation of petroleum. And this includes, just to name a few, contractors from Australia, from Japan, from Spain, from India, from Korea. Of course, it is not uncommon anywhere in the world for disputes to arise between host states and contractors in relation to the commercial arrangements that are contained in these production sharing contracts, PSCs. And in this context, I wanted to highlight some of the very specific advantages that resolving such disputes between host states and the contractors through international commercial arbitration. Now, I'll only speak to 3 specific advantages, which in fact basically summarize what has already been highlighted by the learned speakers before me. So just first, from the host state's perspective, the advantage of resolving such oil and gas disputes that arise under the PSCs through international commercial arbitration is that it allows for confidentiality. Now, this was something that was noted both by Jonathan and by Abhinav, i.e. that the matters are then, the dispute is actually heard by the tribunal in private. The awards and determinations that come out are confidential. This, of course, helps to keep state matters confidential, and of course also helps in the long-term working relationship with the contractor. Because if you think about it, most of these PSCs are given for about 25 to 30 years, if not longer. It is a long-term relationship, and when disputes arise and are determined, it's sometimes best to do it behind closed doors rather than airing dirty laundry in public. And that is what international commercial arbitration offers. Secondly, from an investor's perspective, international arbitration clauses that are drafted into commercial arrangements with host states, which are then backed by a very robust domestic regime, which is based on and incorporates the model law, and which also incorporates the New York Convention by ratification, is often seen as a key indicator or a key demonstrator that a host state is open for business. What I mean by that is investors or contractors rarely want to be caught up in a domestic court because they're unfamiliar with the processes. They are sometimes without any justification, afraid of sovereign risk that would involve. And therefore, they look to having in these commercial arrangements like reliable and known mechanisms that are known to them and are reliable because they are uniform across the world in most parts if it's based on model law. And that's what international commercial arbitration offers. So it's a major tick when it comes to investor confidence that the host state is open for business. And thirdly and lastly, from both parties' perspective, when the host state is party to the New York Convention, now this has been noted quite a few times by speakers, what that provides for is better enforcement options as compared to a court judgment. Now, this is actually very particularly important to Timor-Leste. As I just noted, the contractors in all of the PSCs that have been granted, whether they be for onshore and offshore, there's an array of contractors from all across the world. And if Timor-Leste does have an award against any of those contractors, having ratified the New York Convention would only go to help in making sure that that enforcement can take place. So I really just only wanted to highlight those three things and just stress again on the themes that we have been speaking to today as to the importance for Timor-Leste for international commercial arbitration, especially in one of its most sophisticated sectors. I would like to end by noting and commending the ANPM, who I do a lot of work with, because they have always recognized and wholeheartedly embraced international commercial arbitration. And they have therefore added to and enhanced the sophistication of the petroleum sector. That's all I'd like to say. Thank you.
Thank you so much for sharing your insight, Jintanjali. Last but not least, we have Jose. He's very well known in the Timor-Leste legal community as a law firm partner and has been an extremely valuable member of our team, helping us on the ground and liaising with the key stakeholders. So I will give the floor to Jose to make some closing commentary. Thanks.
Thank you, Christina, and thank you to all the participants and to your excellencies, members of government who have participated. His Excellency Justice Suarez is in the same room as I. Thank you very much. Thank you, ADB. As a legal practitioner in the firm of the Silva Teixeira and Associates, a national legal firm that is often being called on as legal counsel to advise national and international companies of all of those sectors that were mentioned by many speakers today, from the oil and gas sector through to the construction industry sector, and of course now coming online as well, the mining industry sector, because as is not known to many of you, the ANPM and the Timor-Leste government are in the process of putting together for next year a round for expression of interest for the first onshore mining activity that will come online immediately after the Parliament deals with the mining law, which is still currently in the Parliament, just like the arbitration law awaiting approval. Now, as local counsel, the question that we always get in doing the initial advice is it possible to enforce a judgment from a foreign court or a foreign arbitral award in Timor-Leste? Well, we all know that that's not possible. It's not possible for a number of reasons. It's possible, but it's not possible to do it easily. It certainly can be done under the provisions of Article 672 of the Civil Procedure Code, which is a very cumbersome and time-consuming process. But because Timor-Leste is not a party to the Hague Convention on the recognition and enforcement of foreign judgments in civilian and commercial matters, nor the New York Convention, and Timor-Leste doesn't have any agreement regarding judicial cooperation with any other countries, then we must go to the process of recognition and confirmation, which many know is very, very cumbersome, because it will involve an application to the Court of Appeal and a number of criteria that need to be met, which was outlined earlier in his talk by Justice Suarez. All of that makes it undesirable, and also, as Justice Suarez made very clear, the courts here are overburdened with just the work in the criminal administration of criminal justice, family law, and there are only 34 judges. Anyone who knows what I've been about over the last 5 years has been the fact that I've been very enthusiastic, but also very keen to make sure that we have a commercial arbitration law, but also that we have Timor-Leste ratified the New York Convention. Now, it's all great that we've got, and granted, it's good that we've got a law that's been approved by the Parliament, the government, and has now been passed on to the Parliament. However, just before I went on to speak, I got at least 4 direct questions privately through the chat from high-level Timor-Leste participants, including the president of Timor Gap, people in ANPM, people involved in the private sector, and the question was, where can I see a draft of this arbitration law? Good question. It is not easily accessible at this stage because there has been no real public consultation on it. It was delivered to the Parliament, and after conversations with the President of the Parliament and the President of Committee B, which is the relevant committee, the draft law has not yet been tabled in the Parliament and has not been given to the committees to deal with. When the committee gets it, it will launch as it must under the parliamentary rules, standing orders. It must engage in public consultation over those. I've urged both the Parliament and the government to make the copy of the arbitration law available as soon as possible, so as that the legal profession, the private sector, the judiciary, and everybody that has a stakeholding in it must know what it is about. There are certainly no surprises in it, and it is, as Jonathan Lim put it, world's best practice. However, this is where the rubber meets the road now. It's in the national parliament. Anybody knows that when things get into our national parliament, then there will be very, very highly politicized debate. Already, I've had questions from people that I've had to allay the fears of about, for example, the Timor-Leste ratifying the New York Convention and what sort of a threat that might pose to our sovereign petroleum fund. Because there is a perception that if Timor-Leste was to ratify the New York Convention, that for some reason, then any litigant against the state of Timor-Leste may be able to get easier recognition and enforcement. It takes a lot of time to explain to the stakeholders and some of these people that have reservations, which includes some judicial officers I've spoken to, that whatever exposure the Timor-Leste Petroleum Fund may have, should Timor-Leste ratify the New York Convention, it is already exposed currently, because our petroleum fund is either invested in foreign stock exchanges or in the US Federal Reserve. But these are important issues that must be debated nationally and domestically. And that's why it's important that that all of these, the arbitration law, the ratification proposal, and the proposal to amend the Civil Procedure Code must get some public consultation as soon as possible. A number of lawyers, Timorese national lawyers who work for our state institutions, that prior to coming onto this webinar, were asking me also, what the details of this arbitration law was, because they, of course, as professionals in the area, have an interest and have a right to contribute. Of course, it took the best experts that we could find, that the ADB could find, and it obviously took best practice and resorting to the UNCITRAL Model Law, which does not need much reinventing of the wheel, but national stakeholders must still be able to have a chance to analyse, evaluate, and understand this. Because if that does not happen, then the politics will take over, and it can, just like anywhere else at times, take over and bring undone any of the best intentions that may be embodied in legislation. Before I close, a couple of very quick comments. In Timor-Leste currently, in terms of the possibility for ad hoc arbitration, we see that come up quite often. And one of the really big obstacles tends to be the cost of arbitration. And the cost of arbitration in institutionalized arbitration in some of the well-known regional centers tends to discourage parties from engaging in arbitration. And in some instances, they've actually chosen to bring cases into local courts rather than go to arbitration. I think there's something that needs to be looked at very, very carefully. And also, the other major challenge that Timor-Leste is going to have is that quite a number of our very large infrastructure projects involve Chinese state-owned entities as the principal contractors. And a lot of the stakeholders, including lawyers and advisors in the government ministries, are very keen to have some input into ensuring that that particular specific need for Timor-Leste, because of the enforcement difficulties that can occur when trying to enforce in the People's Republic of China, can arise. I have nothing really further to add to, except to say that in addition, as I mentioned earlier, in addition to the the oil and gas sector, the construction sector, I think we will need to put some attention into the mining sector, because the government's program, once the legislation is enacted, will mean that there will be mining concessions issued, and there will need to be some real quick expertise obtained in order for there to be a smooth implementation of any, well, I'm confident will be a future arbitration law. I'm told that as far as the parliamentary timetable is concerned, we shouldn't expect this arbitration law to be dealt with by the Parliament until the middle of next year. As I said, they're dealing also with the mining law, and that's been on the books and in Parliament since 2015 or 16, I understand. So they're putting a lot of priority on that. And there are a number of other laws, including public financing and procurement laws, that will also need to be addressed very quickly. So I think what we will need is we will need to engage all stakeholders, private sector, legal profession, and those professionals that work in government institutions to get together and to lobby Parliament to give due attention to this as soon as possible. And if possible, by the end of this year, have this tabled before the parliamentary committee that needs to deal with. Thank you very much again, ADB and Christina. It's a pleasure also to listen to some of the distinguished experts and speakers in the area. And we look forward to your continued engagement in order to advance Timor-Leste and the commercial arbitration in Timor-Leste, which will assist greatly in all of us answering that question: is it possible to enforce a judgment from a foreign court, a foreign arbitral board in Timor-Leste? It'd be nice to say yes, New York Convention, our arbitration law. Thank you.
Thanks, Jose. Thanks so much for that helpful wrap up and all the information and for all your help. And to all the participants, ADB, UNCITRAL, all of us are here to support with this reform. And thank you so much for just really engaging in the conversation. To continue the conversation, we will have a third international conference in March 17th. So if you'd like to, and it'll be a hybrid event from Sydney and also via Zoom. So if you'd like to participate, and continue this dialogue, please let us know and we'll send you the Zoom links. I think due to time, I think we'll close. But again, just want to thank Justice Soares, His Excellencies, just all of you, our experts, and just our team for a really informative, engaging webinar. We plan to post this. Well, we'll edit it. We'll post it on various places. So we'll send you the link when that's available. So we look forward to returning to Timor when COVID's over, hopefully. And again, thank you so much for tuning in. All right, have a nice evening. Take care.